Welcome back to the Protecting Homeowners Podcast. I'm Mark Dan.
Yes. Okay. So now I want to talk the opposite. My house sold for $20,000, but unfortunately, I've never made a good financial decision in my life, so I owe $300,000 on the house. What happens?
Whitney, do you want to tackle that one?
Sure. So if the property sells and there's a deficiency, meaning that you owe more on the property than, the scenario you just referenced, the plaintiff who has judgment in the case has a 2-year window to execute on that judgment.
And what happens if they don't execute on that judgment within 2 years?
Then they're time barred from executing on that judgment.
So if I skate away and I manage to dodge them and they don't file anything against me for 2 years, it's just a wash and I get to go on with my life?
Yes.
Yeah, no, that's exactly right.
Okay. And a judgment, then they would file a lawsuit against me, or how would that work if they find me?
Well,
no, they would just simply file an execution like a wage garnishment or a bank attachment, or if you own other real estate. Now, there are a couple qualifiers here that I'd like to touch on.
Yeah,
the
please.
First of which is that the money judgment that the bank obtained is against the property owner, and the property owner has not filed a bankruptcy. So there has to be a money judgment that the property owner actually owes. The second one is that this applies only to residential properties. It does not apply to commercial properties.
So what happens differently in a commercial property setting?
The judgment remains as a normal judgment and can be collected as long as the judgment is not dormant. So they have a considerably longer time to try to execute on the deficiency judgment to try to recover that deficiency.
Right. Now, I always seem to be the negative one here because we talked about people getting money, and honestly, in the 15 or so years we've been doing this, I've only seen a couple of situations where a lender, even if the borrower hasn't filed bankruptcy, where the lender has within the 2 years moved to execute on or to seek the money. Generally, because I would think it's because the homeowners doesn't have a lot of assets beyond their home, but it's just not been the trend that we've seen here in Ohio anyway. I understand they do it more often in some other states, but so once you're past that 2-year window post confirmation of sale, then you are out of the woods, and you won't have to file a bankruptcy to discharge that debt if that's one of the options that you have. So but those are things to think about. But on the downside, what we just were dealing with, Whitney and I were just dealing with a situation involving a predator that preys on people who have money sitting at the clerk of court's office post confirmation of their foreclosure sheriff sales. What are the things that people should look out for if they get contacted by somebody telling them that they're a bounty hunter or a finder, and for a small percentage, I think I can get you money from the courts related to your foreclosure?
Okay. So as Andy said earlier, that money belongs to the title owner of the property. So if somebody contacts you and says that they are, that they can help you or assist you, and they want a percentage of the proceeds, be wary, because they are charging you more than an attorney would charge you to file the appropriate motions so that you can receive your funds.
Yes.
Agreed.
Yeah.
There's nothing truly magical about the application process. And if you do run into a situation where there's another lien holder that is seeking to take some of that money away from you, an attorney is going to be far better situated to deal with that than some sort of unclaimed funds bounty hunter, who, as Whitney says, is going to charge potentially considerably more than a qualified lawyer would for doing the same work and doing it better.
Right. If you're post foreclosure and you believe that there's money that's left with the clerk of courts, we're happy to bring that motion on an hourly basis, which shouldn't cost you more than at most a couple of $1,000s to litigate the case, unless, as Andy points out, there might be something nefarious going on. If you've been overcharged by a bounty hunter, there may be claims that you have against that bounty hunter for any misrepresentation they might make to you in the process. But there are boiler rooms of people that spend their time looking for this stuff, and they scrape the websites of the county clerks of courts around Ohio and around the country, and prey on people who often, act like this is found money. This isn't found money. If there's a surplus at the end of a foreclosure, that means that's money that you've paid down on your loan, and increased potentially by the equity that's grown in your house from the improvements that you've done and all the things you've invested. That's your money, damn it. And you shouldn't have to share it with somebody else. So that's something that's also important to look out for. I mean, all of this to me underscores the importance of, and I don't know why, because we've been doing this for 15 years. Boy, when foreclosure was in the news all the time back in 2008, 2009, 2010, people tended to pick up the phone and call us very early in the situations, even before sometimes a foreclosure complaint was filed in court. The minute, and I think the same should still apply today. If you've fallen behind on your mortgage for whatever reason, and God forbid you get sick in America, because you can end up in bankruptcy. You could end up. I had heart surgery. Thank God I had health insurance. But that heart surgery was $165,000. Many in my family would say that wasn't worth it. They would have just let me go. But fortunately, they didn't have that choice because I had health insurance. But even the unreimbursed part of the health insurance was in the tens of thousands of dollars. For most families, they don't have that sitting around. And so, a medical emergency could put you in a situation where you're falling behind on your mortgage payment. That's the time to consult with a lawyer early in the process, because the options we have to help somebody, if they reach out to us early, before a foreclosure is filed, within 28 days after they're served with a foreclosure complaint in court, it's 1,000 times better. We can do much, much more to help somebody in those circumstances, because you have all the options on the table for you at that time. And whatever leverage you have and whatever protections that you have that have been created in the Dodd-Frank Act since 2008 and the Ohio Residential Mortgage Loan Act, which was amended I think in 2011 or 12. Those protections you can only exercise if you don't sit on your rights. And if you do sit on your rights, and there are claims that could have been brought in a foreclosure case that's pending against you, you're forever barred for bringing those cases, bringing that case. And a lot sometimes there are issues with the application of payments. There are unfair and deceptive business practices that mortgage servicers engage in. We still see examples of mortgage servicers dual tracking, which means that you've reached out to your mortgage servicer for help. Used to drive me crazy back in 2008 and 2009 when President Obama got on TV and said, if you're behind in your mortgage, the first thing you should do is reach out to your mortgage servicer, because they'll tell you what's best for you. Now, that's not necessarily completely wrong, but damn it, your first call ought to be to a lawyer, to find out what your rights and responsibilities are, because the last thing the mortgage company is going to tell you is all the ways you can sue them, or counterclaim against them if a foreclosure is filed. And they're staffed, in our experience, often by very poorly paid, very poorly trained people who are answering those phone calls that you might make to them. So if you've been sued for any reason, whether it's for foreclosure or for a debt in court, the very first call you should be making is to a lawyer. And most firms, including ours, will handle that initial consultation for free. We won't always be able to represent you on a contingent fee basis, but we might be able to work out something that's manageable for you to be able to pay us to defend it. That goes especially for second mortgage cases. One of the things we were able to convince the Ohio General Assembly to do a few years ago is to create some extra notice that has to be given when a second mortgage holder brings a foreclosure action, because even though the foreclosure action, it will probably result in that second mortgage company getting a lot less than the first mortgage company does. They often will bring those cases as leverage to try to get you to pay them on a second mortgage that you may or may not owe them. So look, I mean, as a rule of thumb, if anybody sues you, run, don't walk to a lawyer. Call a lawyer, call somebody that's experienced in representing consumers who are being sued for debts, lawyers who are experienced in foreclosure defense, and we can walk you through that process, and hopefully find an affordable way for you to be able to hire us to help you. Look, it doesn't do us any good if we charge you something you can't afford to pay, and so we have options that are available to our to new clients to be able to help them get into the mix. You should not be reaching out to a lawyer after there's a foreclosure judgment against you, after there's a sheriff's sale, or even when you're on the eve of a sheriff's sale. Andy?
Yeah, well, never say never.
Yeah.
You should reach out before, but if that's the first time you can reach out to a lawyer, absolutely do it.
Yeah, no, I absolutely agree with that. So yes, and there are options. And again, we talked about this on this podcast, but I can't tell you how important it is. You also need to have a lawyer that isn't just doing one thing. You go to a bankruptcy lawyer, he's going to give you a bankruptcy. Because kind of if you go to a carpenter, he's going to build you a wood house. You go to a foreclosure defense lawyer, he's going to give you a foreclosure defense. You go to a bricklayer, he'll build you a brick house. We're not like that here. We try to treat the whole patient that comes into the office, not just a particular symptom that's in front of us. And in our view, being in foreclosure is a symptom perhaps of a larger set of legal problems that you're encountering. And the tools and the remedies, there are choices sometimes. One of the things to know is that there's also a time for time for bankruptcy and a time not to file that bankruptcy, even if somebody qualifies. So you may be eligible to file a Chapter 13, but that may not be the best option for you to protect your house and stay in your house. You might be able to, without having to file bankruptcy, apply for a modification, defend that foreclosure. There might be defenses to that foreclosure that you're not aware of. And why should you be? Everybody doesn't know everything. I think that the folks in the office make fun of me sometimes because they'll hear me say ask a client what they do for a living. And we want to know that for a couple of reasons. Karen's going to want to know what you do for a living so we can figure out how much income you have coming in, so that we can determine whether or not you're going to qualify for a loan modification. But if somebody tells me that they're a plumber, what I will tell them is, how about I'm going to make a deal with you while we're representing you. I won't fix any toilets if you don't try to practice law. And somehow that has a little resonance with people that works for works for that relationship. If I say that to you, by the way, I'm not mocking you or making fun of you. I'm trying to make a point. Sometimes everybody doesn't appreciate my sense of humor the way the people that work here do, because they're obligated to appreciate my sense of humor because they work with me. But so again, I apologize in advance. But try to get through my dad jokes in our consultation, and hopefully you'll get to some very good legal advice from this, from the experience that we have here. I didn't get this gray hair by mistake. Andy had a full head of hair when he started doing foreclosure defense cases, and there it is. We weren't as lucky as Karen and Whitney to look so young and beautiful at our ages, and with all the experience and don't mistake those innocent looks for lack of experience, because the two of them know what they're doing for sure. So, but in any event, reach out to a lawyer as early as possible when you have any inkling that a foreclosure is on the horizon, because there are defenses, there are claims that you can bring against your mortgage servicer. You'd be surprised at the robust consumer protection statutes that exist to protect you. It's not just the Real Estate Settlement Procedures Act, which is the federal enactment that broadly expanded the rights of borrowers and homeowners in foreclosure after the Dodd-Frank Act passed in 2010. In Ohio, it's not just the Residential Mortgage Loan Act. There are other statutory claims. There's the Fair Debt Collection Practices Act. There's the Truth in Lending Act. There are state fair debt laws that are out there, state homeowner protection laws if you're outside of Ohio, in addition to the Residential Mortgage Loan Act. I mean, and look, it's complicated, and it's not. And honestly, every lawyer that does this work doesn't have that level of experience. One of the beefs I've always had with our profession is that you can hang out a shingle as a lawyer and take on cases where you have no expertise at all, as long as you've passed the bar. And that doesn't mean, what Andy and I thought it meant when we went to law school. We thought we were going to get to go to a bar. Unfortunately, that was not what the bar was. The bar was that's a serious test, but it tests your general knowledge about practicing law. It doesn't necessarily qualify for you to do any particular thing when you're out. And there's some wonderful things about that in the profession, because I've had the opportunity to do all kinds of different work. But I can tell you that I'm not going to hang out my shingle or make the representation that I can do something unless we have experience doing it here. So that's so please consult with a lawyer. And if you don't have a feeling that lawyer that you're talking to has confidence in what they're telling you, get a second opinion, get a third opinion. I mean, every lawyer is not for everybody. Everybody doesn't want to put up with my corny dad jokes. And frankly, the fact that we often charge more than other firms charge for the type of foreclosure defense work we do. We do that for a reason, because we want to be able to take the right amount of clients so that we can properly service them, and because we do good work and we're experienced, and you need to pay for quality sometimes in these types of situations. It's not a commodity. It's not as simple as it looks. Just like, when I look at a backed up toilet, I know that there could be a variety of reasons why that happened, and I'm going to always guess the wrong one. So I rely on our plumber to exercise their professional judgment and to give us recommendations about what to do. And that's what we do here. I mean, it's really not that much different than probably what you all do in your own work life. So, is there more for people that are post judgment? Because I think that's really where we started out to talk about here. what other things do people need to know if they're far down the road in their case before they haven't had a chance to hire a lawyer yet?
Well, there's always, even after sale, there's always the right to redeem the property, which means to pay off the entire judgment. Now, that may seem like it's beyond most people, but I've had several clients over the years who, even though they didn't file an answer to the summons and complaint, they didn't do anything to defend against the foreclosure. But then they realized, gee, I'd really like to keep the house. And, maybe they get an inheritance, maybe they sell another piece of property, what have you. They can pay off the entire amount of the judgment. So that is an option. And we can help people manage that process by making sure they pay the money to the right place at the right time and in the right amount, because that can kind of be tricky at times. So that's another important aspect of post-judgment, even post-sale,
right
of redemption. And just to let you know, in order to redeem a property, you must do so before the sale of the property is confirmed by the judge as having been in compliance with all law. So there is a time limit on it. But you can also request the judge for more time after the sale in which to redeem the property. So that's one way to buy a little bit more time if you need some time to come up with the redemption amount. But the right of redemption is exceedingly important in the foreclosure context.
No, that's exactly, and we've done that. In Whitney, in particular, our office has mastered the redemption process, which is not easy. And you want somebody that's for whom it's not their first rodeo. And she's done a great job for a number of clients. You have to move to stay the confirmation of sale. And look, it's people love when we give answers like it depends. As a lawyer, my favorite lawyer answer, right? It depends. I mean, when does the sale get confirmed after a sheriff's sale? It depends. It's up to the lender to ask the court to confirm the sale, and if they don't move forward, it could be years. And if they do move forward, it could be weeks. And so, one of the first things we do if somebody has a mind to redeem, and we've seen people borrow money from relatives. We've found people who have found lenders who are willing to finance a redemption for them, and they're out there. They're not. The terms aren't always terribly favorable, but that happens. We've seen people that have been able to sell their property, and with our help, been able to redeem it and then sell it to somebody else. That requires a little bit of trust, because you've got to pay that redemption amount in full before that foreclosure gets dismissed and your title is clear, so you can sell it to somebody else. But we've pulled that off more than once here on behalf of our clients, and that's particularly important to people that have equity, because one of the things that happens, and this is another thing that I think would be helpful for people to understand, is at a sheriff's sale. Or now there are auctions that are done, private auctions in Ohio that are allowed in lieu of a sheriff's sale. A lender can do what's called a credit bid. So they can bid up to what's owed on the property without having to put any money up. So they can bid the property value up against people who have to pay cash within 30 days after the sale in order to purchase the property at a sheriff's sale. And that happens sometimes, though. But it really doesn't matter to the bank or the lender where that bidding stops. So it could stop far short of what you could sell that property for. So if you're waiting for the property to sell at sheriff's sale and think you're going to get the full equity value of your property out of that, it's not going to happen. And so you need to be really, again, just another reason to be in the mix so much earlier in the process than possible. And at the same time, they're going to certainly bid up to what you owe them on the property. That just makes sense. And so that's why the redemption value, the amount you have to pay for redemption, is the total of what you actually owe the lender to be able to keep the house. It's actually a little more than you would have to pay them if you sold the house, because there are certain fees and charges and legal fees that are allowed to be added in a redemption that aren't allowed to be added in a payoff of the loan. Again, sounds complicated. It is, but that's why you want to get experienced, competent professionals to guide you through it. Anything else we want to add about the life after judgment in a foreclosure case? I have a question, Karen. Is it possible to get your loan modified, even if you're post-judgment in a foreclosure?
Well, anything's possible, but your chances are slim to none.
Okay. All right. Have we had success in helping people apply for a modification post-sale?
Not yet, but I'm about to, not post-sale, no, but I'm about to do one on a loan that's matured.
Okay. All right. What does that mean? Andy, Whitney, who wants to answer that question? What does it mean that a loan is matured, and why does that matter to people who are homeowners who might still owe money on that loan? Can a loan be matured yet unpaid? Andy?
I was going to have Whitney answer that one. I've been talking a lot.
Okay. Whitney?
So if the loan has matured, it means that it has met its contractual limit. So if you have a 30-year amortization of a loan in your mortgage, and your mortgage says, your loan's going to mature on August 1st of 2026, then that means the loan is now able to be called due if it has not been completely paid up to that point. Hopefully you've made all your payments and pursuant to the terms of that original contract, and the payments will no longer be necessary. But if you still owe money on that loan and the loan has matured, the owner of the loan can call the loan due at that point. And we do see foreclosures filed after the maturity dates.
Right. So if you're behind and your loan matures, you got a serious challenge ahead of you, because the modification opportunities aren't necessarily always the same as for an unmatured loan. You can't modify a loan that's come to its end. You can, but it's very difficult to get a mortgage servicer to agree to do that, and that's the challenge that we have from time to time. So, what any closing thoughts that people would like to share for folks who are watching who are far into their foreclosure process or post decision?
It's never too late to call a lawyer. There are still options. I mean, up to sale, you can still file a bankruptcy and stop a sale. You can attempt to modify the loan, especially if you're 37 days prior. There are still options. After judgment, your options are very limited. You need to talk to an attorney. Filing like I said, you can file a bankruptcy up to sale. After sheriff's sale, things become extremely dire, and you need to redeem the property at that point. There's no chance at reinstatement, nor will a bankruptcy stop. But also, if you're sitting in limbo and there's been a sheriff's sale and you need to know what to do, or you need more time to stay in a house, you are allowed to stay in your house through confirmation of sale, and then honestly after, until I would think that either the lender who would purchase the property at sale or the new buyer executes a writ of possession against you.